also known as Consumer Credit Central, your reliable wall of information on consumer credit issues, brought to you by Mohau Debt Counseling. I'm Holly Kubane, and with me is the incredible expert, Mr. Mohau Mutaung, founder of Mohau Holdings, who will be my guest and contributor on a range of credit-related discussions. Remember, if you have any questions on your mind, you're always welcome. You can hit us up on our social handles displayed at the end of this video. You can also leave a comment on the section below, or keep us alive by bringing in the information and clicking on the like and subscribe button. Now, Consumer Credit Central aims to give you clarity on any questions that you may have as a consumer, and also to provide awareness on a range of issues in connection with the National Credit Act. This is our first of many episodes where we try to look back in history and on how we got to the current legislation. We look at how and when the National Credit Act was passed, the role of the regulator, and how the Act actually protects not only the credit providers at risk, but also you and I as the consumers that are likely to face these issues. In recent reports on South Africa's household debt indicates that many households are actually facing mounting debt and are starting to feel the uncomfortable strain of financial pressure. With this, we actually end up with many families struggling to manage their expenses as well as meet their financial obligations. So this obviously indicates that our households are under immense pressure. But then again, this seems to be the case almost every other year. And I'm so happy to unpack this topic and more today with Mr. Mohau, because I'm sure you and I are looking for the same answers today. Mr. Mohau, it's a pleasure to have a sit down and conversation with you today.
Thank you very much.
Okay, so in opening, and in your opinion, how would you sum up the South African consumer? Do you think we are reckless spenders? And what are some of the situations that are leading up to this? How do we find ourselves in this kind of situation?
Thanks, Holly, for having me once again. Sources indicate that South Africans are over-indebted because they live way beyond their means. And there is a number of factors that causes that, or some of which is that peers, people that they've grown up with, to match up the standard, to live what they actually aspire to live, but never really got to get to that life. It so happens that people don't always get what they want out of life, but yes, they do live above their means.
I think that it's something that we hear quite often, but I'm glad that you've clarified it. So I just want to understand then, with that being said, when was the National Act then introduced, and why do you think it had been introduced or inspired to be introduced?
National Credit Act was a real need for this country. It was first launched, it was first written and came into law only in 2007, 1 July. But it was done on the 15th of March already, in 2005. But then, obviously, it takes time to promulgate and go through the process of making it law enforceable. But yes, we needed it. The reason for that is that prior to National Credit Act, we had a number of legislation regulating credit market. One of which was usury, which regulated the credit card market. And we had unsecured, purely unsecured, which was called Consumer Credit, some act that talks with open credit, and that was a bit unfair because credit provider could charge any amount. There was no capping. Now there is capping.
So how does that go hand in hand with NCR then? Could you tell us about NCR and its responsibility to the public?
National Credit Act, being the act, had to have a watchdog. NCR is the watchdog. They oversee whatever, they enforce whatever the act say. One of the things that they do is to make sure that there is a fair credit market competition. People can access credit easily and legally. So prior to that, people could do anything and everything. But with National Credit Act, the National Credit Regulator overseeing that, there's a fair competition, streamlined processes, fair computer fair laws within which you must practice credit. And also, people have now advantage of getting what we call pre-agreement quotation. Pre-agreement quotation shows the consumer what's going to be paid at the end of the term. Yet before National Credit Act, you get a surprise. You buy a thing for 100,000, end up at 400,000. Now you know already it's kept at a certain percentage. Before you can even take up that, you know exactly what you will pay at the end of the term, which never existed before.
Who's responsible for that, for helping you understand what you'll be paying at the end?
Credit providers are now expected to give 7 days before they bind you into any agreement. That document has got everything that you want to know. How much the interest in the beginning, how much any other, there's no more hidden costs. It stipulates clearly how much at the end of the term the whole loan will become. Let's take one example. You buy a furniture for 100,000. They would say just pay 200,000. And the actual initial is 4,000. But if you look at the installment, it's 450 for 24 months. Already, you can see it does make sense.
Do you have the right as a consumer to fight against those repayment agreements to best suit you as a consumer?
With the National Credit Act, there is a room to play around. You can negotiate the interest rate because we know they are kept at a certain rate on a certain type of loan. Yes, the consumer can now negotiate interest rate, which came along very, very handy because prior to that, it was more like people were desperate for credit and there was no way you could negotiate. Getting a credit was good enough.
How has the legislation been a victory for both the consumer and the credit provider? How do the two actually both benefit from this?
I would say it benefits both, though initially it was not well received by the credit providers in a way, because you kind of cut their monies they were making in between. It helped the consumer, the credit provider, purely by creating a fair and a balanced competition, which is number one. And there's no more things like one can offer a better or far better rate than the other. They still can, but practically the playing fields are level. That's number one. Secondly, the credit provider knows that it will benefit them because now suddenly everybody has to register. Not everybody really was registered then. Now that everybody has to register, it has taken out some of the people which were not supposed to be there. So it has kind of narrowed down the number of credit providers. And advantage for the consumer is that the consumer can now see exactly what they're getting themselves into. That's number one. They can also obtain a free credit report once a year, for free, which never existed before. Those are some, but it's quite a number of those advantages that the consumer enjoy.
Do you think the consumer actually was aware that they can turn in that credit review, you said, at the end of the year? Do they know?
Not every consumers really know, but it's one of our purposes here to inform the consumers of what they can really use or attain or touch or tap into as consumers.
So I'm trying to understand what are alternative paths or alternatives that could be taken in case now a consumer cannot meet these financial commitments that they made.
There is a number of them, but I'll mention three for now.
Okay.
One is consolidation. Consolidation comes in a place where somebody cannot afford to pay their debts, goes to a credit provider. Credit provider put all those debts together and charge only one interest rate on the overall of those debts and pays one installment, which kind of helps the consumer. But if we were to go technically, it is more cost because every single loan has got interest in it. We pay credit, we pay the interest for the money. But then the second option is which is readily available is debt review. Debt review consolidates all your debt, like I've just said consolidation does. But the difference is that debt review does not start from scratch. You continue with your actual debt. You can actually negotiate your installment, get them reduced, especially if a debt counselor can see that you already paid the principal amount. Therefore, you can actually negotiate the principal and the interest rate, reducing the installment, it might lengthen the period, but it would have given a big relief to the consumer, which they need so much. The last one, which can also help, should be the position. There's a prescription S68 of 1969. It says if a debt was not collected in 36 months, the consumer has got the right to demand a written off.
Oh, okay.
Totally. But that is except the bonds. The prescription period is 30 years. Any other loan is 3 years. If any consumer can prove that in 3 years they had this debt and it was up to the credit provider to collect and they did not collect, then will be written off.
Okay, let's talk about that, having that credit being written off. What are the procedures? Do they look at your affordability? Do they do any legal research on your background, or is it just automatically written off?
It should be automatically written off, but we do have a situation where credit providers try to sell their books to other people to pursue and collect the notice to the landlord. Once it's prescribed, it's gone. And if a consumer can be able to exercise it the right way, will walk away freely. But there are two things that consumer can cause themselves trouble. If they make a new arrangement on the debt, it revives the debt. Or secondly, if they enter into any form of arrangement, it will revive the debt. The third one, if they pay even 50 rand, it will revive. People will know probably that in some cases they get asked, even if you can pay 50 rand, it's not bad. All they want to do, they want to revive the debt.
Oh.
And once you revive it, it needs another 36 months to prescribe.
This takes me back to, let's make an example. You get a phone call regarding your debt. Do you think answering a phone call and acknowledging that you are the one speaking on the phone is the same as making an agreement to settle?
Most cases, more often than not, credit providers calls are recorded.
Yes.
And it will inform you that they are recording the conversation. Once they've recorded that recording, it is admissible in law. Therefore, by admitting on the phone that, yes, I know about this debt and I will pay you month end in whatever day you actually revive the contract, it is now live and enforceable. But whereas if you take the call and you say, I don't owe you anymore, 36 months has passed, they probably never collect.
So before we get to the differences between debt counseling and consolidation, I heard you speaking of when they make arrangement that they look at the different kind of interest rates that they could pay their loan. What does that depend on? Does it depend on your affordability or your credit check? How does the interest actually depend on which one they are giving you as a consumer?
That process is actually handled by a debt counselor.
Okay.
If a consumer gets to that point that he cannot afford to do or to make up the installments, must approach the debt counselor. If they approach the debt counselor, it is the debt counselor's part of functions and expectations to go through the whole history or the whole profile of the consumer. In there, the debt counselor can actually see which one is actually run the rate, their costs, which one can they reduce, which one they don't really have to talk much about the interest, which is a new date, depending on the life of the debt. That's actually a very, very technical and a purely check on for the debt counselor to actually exercise.
Okay, now tell someone like myself who would probably like to understand the difference between debt counseling and debt consolidation. I'm sure there's quite a confusion. It's something that someone always would like to understand. What's the difference between the two, or how do they work hand in hand?
Debt consolidation is done by the financial house, meaning a bank or any financial institution. What they'll do, they'll take all their debt and put it together, loan you an amount that will cover everyone. There's a few things that I want to mention in that space. One, we know every price for debt is interest. So whatever debt you already have as a consumer, it has got to keep interest in it already.
Okay.
So if you go to a credit provider and ask for a bigger loan, that loan is going to add the interest on a higher amount over and above the interest that every single credit provider has already added onto their loan. So in essence, we're saying here, whilst it gives a relief that you don't have to pay that one and that one, it's one under one umbrella, one roof, one installment, but you're actually paying twice the interest, which is critical. With debt review, if you come to a debt counselor, the debt counselor will take you all the amounts, similarly in putting them together and see who you owe, put it together nicely, and then write to the credit provider and propose a new installment with all of them together. But it will be done in such a way that everyone will have the portion payable to them. In that case, you are not starting a new debt. There is no new interest that you are incurring as a consumer. It's a continuation that gives a lot of relief to the consumer who's over-indebted. And it protects a lot of assets. It protects your name against possible blacklisting. It covers areas that which normally consolidation would sometimes have a problem covering.
Okay, so to get to what we were talking about, getting to consolidation and so on, what are the actions that are likely to be taken by the credit provider in such a situation, and what can the consumer do to actually avoid such a detrimental action to get to that point?
If a consumer goes to another finance house to get more loan, to get another loan, I can tell you now credit providers are going to be celebrating because they'll be paid out right out.
Oh, okay.
And they're going to be very, very happy. In most cases, a person like a debt counselor, which I am, I would never recommend consolidation for one reason, one big reason. One reason is that should you go for debt consolidation, all those credit cards, all those credit limits, those revolving credits becomes available immediately, which can actually attract the consumer to go deeper and deeper into trouble. Means even though you pay one installment, you can actually go tomorrow and take and revive the credit card, or spend on a credit card, or spend on a revolving credit, which will actually want somebody, or at the end of the day, somebody will have to go back to another debt consolidation. Whereas with debt review, we block you off from taking your debt because you already have a problem. There's something I want to mention there. There's a myth that says debt review cannot be removed. Well, if you have paid up all your debt, debt review will be removed. The flag will be removed. And it will never have any reflection on a credit profile. It will go completely. The act was drafted in such a way that nobody can say you're once under debt review. That picture is not there. So I can tell you now, once you are under debt review and you have paid it up, it will be removed altogether.
I'm so glad you mentioned that. So, in your opinion, you feel like debt review will always be better than debt consolidation?
In this country, we always have debt consolidation. Obviously, clearly, it states the creation on the initiation of debt review was intended to close a gap, which existed until debt review came into play. So, consolidation has always been there for many, many years. Time immemorial, but it was not addressing the big problem. The big problem is going deeper and deeper and deeper into trouble, into debt trouble, into debt trap. Let's call it that way.
I just want to touch on one thing before we move on. So, where is the consumer when things get to a point of repossession, for example? Where are they in this whole equation? Are they at the stage of debt counseling or debt consolidation? Where are they with their debt when it comes to repossession of items?
Repossession will only come into play with cars and houses.
Okay.
Nobody can repossess anything against your personal loan.
Yes.
The worst they would do, well, if they were to go to court and get a court order, maybe they'll look at it, but nobody really pushes it that far. But a car and a house are the first one that the bank will quickly initiate to repossess. And as a consumer, not everybody is a sheriff. But every consumer thinks anybody knocking the door and asking about the car or the house is already a sheriff. It's not. There is a process that the whole thing must run. For example, step number 1, the consumer must be issued with a document called Section 129. That document is read together with Regulation 130. That document says you are in debt. It informs you, it reminds you that you actually behind that debt. It gives you 10 days to action. You need to come to a debt counselor or pay it up. If you come to a debt counselor, it will be sorted. After that process, if the consumer does not act, then only will the credit provider approach their attorney draft summons. After the summons, they'll deliver the summons on the domiciliary, that address which the consumer gave at the time of inception of the debt. I must mention, people move around, they move from one house to the other, one place to the other. But whatever the address that you used or you recorded at the time of taking out the loan or the car or whatever the debt, the summons will be sent to that address. So it is your obligation as a consumer should be moved to inform the credit providers. Now back to the process. They'll send the summons to that address.
Yeah.
When they get to that address, they'll drop off the summons. People must understand this. Once a section note in name will be delivered, must be received and acknowledged by way of signing for it.
Okay.
But a summons you don't sign for it. Summons can be thrown in the yard, can be put under the door. It is assumed to be delivered in that way. And then they need to give you 10 days to approach your attorney or go back to the credit will settle the debt. If that is not done, then they'll carry on. The credit providers' attorneys will carry on, then apply for what they call a set down eventually, where the hearing will happen and the order will be made. A default judgment will be made. Why it's called a default judgment is because you cannot really defend yourself. The only way to defend yourself is when the bank has made an error. It will be done in your absence as a consumer. Once a judgment is obtained, then they will apply for warrant of execution. From there, they will come and collect their car or auction their house, unfortunately.
Okay, you talked about a consumer not being in position to defend themselves. How about a consumer saying, I did not receive the summons that was left at the address? Because as you said, the summons doesn't need to be signed or acknowledged for being received.
Unfortunately, that part, if a sheriff says he's delivered summons, you have to deliver summons. They're credible. Should you want to challenge that as a consumer, you're actually causing yourself a big issue because the sheriff can be expected to or asked to maybe to identify your house, then you've got serious problem.
Finally, now let's assume that a consumer feels aggrieved by a credit provider's actions and that they feel it is unfair. So what are the appropriate actions that they can take and how long do you think it's likely to drag for?
Thanks for asking that one because people think you can do nothing about it. You can. There's a form called Form 29 with NCR. It's with NCR. You phone NCR, they'll send you Form 29. That's where you report anything that you feel was not done fair to you. Normally, NCR, I've seen them responding in 4 or 5 days, which is very quick. In some cases, I've seen them calling the same day just to confirm the allegations of the consumer. The consumers can use Form 29 at NCR. But even if, before you get the Form 29, by mere calling NCR, you are claiming that register, NCR will action. They've always actioned it. So a consumer protected in that regard.
Okay, that's amazing to know. I've really enjoyed this conversation. Although we have really come to the end of it, I feel like we still need some more time for us to unpack. You have so much information and we appreciate your expertise in this field. I would like to have another conversation with you some other time on some other episode. But for now, I think we have come to the end of our conversation and it's time to wrap it up.
Thanks, Holly. Thanks for your time.
Thank you
Thanks for having me. Thank you.
We have come to the end of our conversation and you can make use of our social handles found on the end of this video. Remember that whatever advice or any direction that you seek, you are welcome to leave us the questions, no matter how big or trivial it seems. Remember, you can also send us any questions or remarks or comments around what topics you would like us to cover on the next episode around credit providers and consumer credit relationship. For now, I'm going to have to close it off for this episode. Stay healthy on those pockets until the next episode. Goodbye.